How long do you have to file a car accident claim in Ohio? After a car accident, most people are focused on medical treatment, vehicle damage, and dealing with the insurance company, not legal deadlines. But waiting too long can seriously hurt your case. In Ohio, there are strict time limits for filing car accident claims and lawsuits, and missing those deadlines can mean losing your right to recover compensation entirely. In this video, we're going to break down how the statute of limitations works in Ohio, the difference between an insurance claim and a lawsuit deadline, exceptions that can change the timeline, and why waiting too long can damage your case even before the legal deadline expires. If you've been injured in a crash, Zoll Kranz offers free consultations to help you understand your rights, your timeline, and your next steps. Ohio's Statute of Limitations. In Ohio, most car accident injury lawsuits must be filed within 2 years of the accident under Ohio Revised Code, Section 2305.10. That deadline applies to many injury and property damage claims throughout Toledo and the rest of Ohio. One important thing to understand is that insurance negotiations do not pause the deadline. Even if the insurance company is still reviewing or discussing your claim, the clock is still running. Key points to understand include: most Ohio auto injury and property damage lawsuits must be filed within 2 years after the cause of action accrues. In ordinary crash cases, accrual usually occurs when the injury or property loss happens. The deadline can still expire while an insurance company is evaluating or negotiating the claim. Missing the deadline can result in dismissal of the lawsuit as time-barred. Wrongful death claims can follow a separate statutory framework and generally use a 2-year period from the date of death. Tolling and exception issues may arise in limited circumstances, but they should be evaluated case by case. Factors that can affect the filing deadline. Some claims require closer review because tolling rules or special statutory frameworks may apply. A lawyer can determine whether the standard deadline controls or whether a different rule may affect when suit must be filed. Examples include minor status. If the injured person was a minor at the time of the crash, Ohio tolling rules may affect when the limitations period begins to run. Unsound mind or legal incapacity. Ohio law may toll the deadline if the injured person was of unsound mind when the cause of action accrued. Government defendants. Claims involving political subdivisions or the state of Ohio can require analysis under separate statutory schemes, and those cases should be evaluated early. Defendant absence or concealment. Ohio law may toll the running of the statute when a defendant is out of state, absconding, or concealing themselves. Consequences of missing the statute of limitations. Missing the filing deadline can end a lawsuit seeking compensation, even when the evidence of fault is strong. As we've established, most actions for bodily injury or injury to personal property must be brought within 2 years after the cause of action accrues, and a late filing is typically subject to dismissal as time-barred. Once that happens, the injured person may lose the ability to seek compensation through the court system from the at-fault party for losses tied to the crash. Waiting can also damage the case before the deadline ever arrives because witness memory fades, records become harder to obtain, and the insurer may gain leverage during negotiations. Limited exceptions may exist under Ohio law, but they depend on specific facts and should be evaluated early rather than assumed. Common consequences of missing the SOL include The court may dismiss the case as time-barred if it is filed after the applicable deadline. The injured person may lose the ability to pursue damages through litigation against the at-fault party. Delay can weaken the claim because documents, witness testimony, and other evidence may become less reliable over time. Settlement leverage may decrease if the insurer knows the filing deadline has passed or is about to pass. Tolling or exception arguments may exist in limited situations, but they are fact-specific and should be confirmed with counsel early. Be careful with insurance delay tactics. One thing many unrepresented accident victims don't realize is that insurance companies may try to drag out negotiations, especially in more complex claims. The longer the process stretches on, the closer you get to the statute of limitations deadline, and once that deadline passes, your ability to file a lawsuit may be gone. That's one reason it can be risky to handle a serious claim alone. An attorney can help make sure delays and negotiation tactics don't put your case at risk. Why you should talk to a lawyer about your deadline. Even if you're not sure you want to hire a lawyer, it's still smart to speak with one early so you understand exactly how much time you have. A lot of people assume the deadline is simple, but different facts, injuries, insurance issues, or claim types can sometimes affect the timeline. And the worst thing you can do is assume you still have time when you actually don't. A quick consultation can help you understand what deadline likely applies to your case, whether any exceptions may exist, and what steps should be taken now to protect your claim. At the very least, you'll walk away with a clearer understanding of your legal timeline and options. Contact Zoll Kranz for a free case evaluation. If you've been injured in a car accident and have questions about your legal deadline, your insurance claim, or whether you may have a case, Zoll Kranz offers free case evaluations. You can call the firm directly or visit toledolaw.com and use the chatbot to start your free legal consultation today.